Hey, good morning and welcome everyone. I'm Zane Dames, the Marketing and Event Coordinator at Digital. I'm pleased to welcome you to your organization needs an IP strategy, another fantastic subject as part of our IP webinar series at Digital. Before we get started, we respectfully acknowledge that in Canada, we live, work and learn on the unceded traditional and ancestral land of Indigenous people. As myself and much of the Digital team are based in Vancouver, British Columbia, we are gathered here on the traditional ancestral territory of the Musqueam, Squamish, Tsleil-Waututh peoples, and we encourage you to take a moment to acknowledge and let us know in the chat the traditional territory that you are joining us from. Please note this webinar is being recorded and will be shared with our audiences in the coming week. If at any point during the session you have a question, please type it into the chat and we'll address them at the end during the Q&A portion. That's it from me, and I'll be handing it over to Jen to get this webinar started. Thank you, Jen.
Thank you so much, Vinay. Bonjour, everyone, and welcome. It's wonderful to have attendees that are joining in from across the country for this month's webinar. Whether you're new or a returning participant to Digital's IP series, we're thrilled that you could join us for this Thought Leadership Power Hour. Next slide, please. Now more than ever, intellectual property is integral in the Canadian innovation ecosystem. For innovative organizations in an intangible economy, understanding the often complicated legal and financial aspects of intellectual property is vitally important in effectively leveraging those assets for the growth and success of the organization. However, simply being aware of or holding IP does not mean that those assets are being effectively managed nor protected, and not everyone comes with a starting point of having a robust portfolio of cutting-edge intellectual property to leverage to create those competitive advantages. And therein lies the importance in organizations having an IP strategy, irrespective of industry and organization size. It doesn't need to be complicated, but needs to be one that is tailored to your business objectives and positioning. Over these next 60 minutes, we'll cover items that include key considerations when contemplating, developing, and implementing your IP strategies, the need to iterate and evolve your organization's IP strategy as your business grows, and supporting resources, where today we're focusing on the new soon-to-launch AccelerateIP program that is part of the Pan-Canadian Elevate IP initiative funded by Innovation, Science and Economic Development Canada and led by New Ventures BC, focused on entrepreneurs in BC, the Yukon, Northwest Territories and Nunavut to manage their IP and develop their IP strategies, and a Q&A portion to follow at the end. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-industry challenges while creating technology products and services that can scale not only across industries, but ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through numerous vehicles, and informational sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing today's Thought Leaders panel. Please join me in welcoming Maya Medeiros, Rachel Burns, and Angie Schick. Maya is partner at Norton Rose Fulbright and an intellectual property lawyer, patent agent, and trademark agent. She has extensive experience in IP and complex technologies, including AI, and advises a wide range of companies on IP strategy and develops tailored IP policies and training programs, ethical guidelines, and collaboration agreements. She is a key contributor to Inside Tech Law on the ethical and legal implications of artificial intelligence, and an adjunct professor at York University, where she teaches on the commercialization of intellectual property. Rachel brings 15 years of experience across program management and marketing to her role of Program Director, AccelerateIP. Previously, at New Ventures BC, she supported the ISI Grant Program, Venture Accelerator Program, and the New Ventures BC competition. She's also held business development and content strategy roles at Langara College and Jane.app. Rachel has a BA in Interdisciplinary Studies, along with postgrad diplomas in Publishing and Education as an alumni of the Writers Studio at SFU. And Angie, Executive Director at New Ventures BC, who oversees the delivery of all its programs. Prior to this, she led teams and oversaw game development and radical entertainment, and has worked in the technology sector for over 15 years in roles such as project manager, market researcher, and strategic communicator. Angie has been supporting technology startups for over a decade and loves working with the entrepreneurs. and holds a Master's of Arts in Communication, where she specialized in technology and society. And with that, ladies, I hand it over to you.
Thank you, Jen. Let me just quickly share my screen. So I'm going to kick things off today, talking a little bit about IP strategy and hopefully giving you some practical tips to develop and evolve your strategy. So why does your organization need an IP strategy? And I'm going to touch on 4 buckets. So in order to protect your core IP assets, you need an IP strategy. You also want to create a culture of IP within your organization, and as well, use your IP strategy to identify strategic opportunities, whether it's through commercialization opportunities or strategic enforcement opportunities. And I'll dive in deep to each of those topics. As starting out, you need an IP strategy to protect your core IP assets. And you don't necessarily have to chase down every single IP asset of a company. You know, there could be copyright in a memo, an internal memo, or there could be copyright in your core backend source code. So obviously not all IP is created equally. So try to identify those core assets and focus on protecting those as a starting point. And of course, evolving that strategy as you develop your business, and you might pivot or adapt to new technologies or new products. So keep pausing, particularly given the long life cycle of patents. Patents are, a 20-year term, and that might not actually be short depending on your technology domain. In the biotech space, for example, there might be more regulatory hurdles, but generally, 20 years is a while. And so you want to pause and make sure your IP strategy isn't static and set in stone or set in one time, and is not evolving as your business is evolving or the assets themselves evolve over their life cycle. Generally, you create a portfolio of IP registrations or IP assets more generally. A defensive portfolio is typically the game to protect your freedom to operate. It's not a perfect solution to have freedom to operate if you have a wide range of IP registrations in your portfolio, but generally it can help because you have a defensive mechanism to then articulate what your IP assets are and provide those to IP examiners, whether it's trademark examiners or patent examiners, to then refuse or reject later filed applications for similar subject matter. So that's just one opportunity to indirectly protect your freedom to operate as well. Similarly, companies may be hesitant to assert IP infringement claims against your entity if they do a little diligence and see you have a robust IP portfolio. So that defensive mechanism, again, doesn't require a lot of action vis-a-vis that entity that might also hold IP, similar IP, but at least it could stop them from, poking you, because you might return with a counterclaim, of course. So that's another defensive mechanism. So defensive mechanisms are typically the core IP strategy, not necessarily enforcement, but we'll talk about strategic enforcement as well. Some IP assets don't necessarily require you to take positive steps to obtain a registration. For example, trademarks, you can acquire common law rights just by using the mark, or copyright. As soon as you create and fix a new work, copyright attaches. But other types of IP protections like designs and patents require active steps for registration. Trademarks also can be registered, as can copyright, but particularly trademarks, it's recommended to proactively register to confirm those rights, because a search is done vis-a-vis other marks in the area, and so you can get at least initial feedback from an examiner whether you actually can use that right. So thinking about IP registrations is important, because just creating the asset alone doesn't necessarily mean you get IP rights attached to that asset. And when you're looking at registrations, one thing to keep in mind is geographic scope. Generally, there isn't an international IP registration. There's application processes at the international level, but you need to consider country by country or region by region. So just wanted to highlight geographic scope being important. I'm going to dive in a little bit deeper into protecting your IP assets through different forms of intellectual property rights. And generally, you layer different types of rights vis-a-vis one product. And I'll dive into an example. So here's just a visual diagram of different types of rights. I mentioned copyright, for example, patent rights, design rights, database rights as well. There could also be trade secrets and confidential information, as well as trademark rights and brand rights. Generally, also, there could be rights through contracts. So there might be rights of ownership, for example, carved out in relating to know-how. So that could be a confidential information or trade secrets, but it would be layered with that contractual protection. Non-disclosure agreements as well, you see come in relation to IP assets. Also, data can have different rights depending on the country. So I just highlighted Europe as an example. So here's just a high level, as I mentioned, overview of different forms of IP rights that can come into play to protect your assets. I wanted to dive into an example of an electronic device. So I have an image of an electronic device, and we can kind of roll through some different types of IP rights that would attach to this device. So you would have patents, for example, on the processes. That could be, software patents, for example, and some of the processes or the interaction between hardware and software. For example, you might select an item or an icon with the keypad, and that might trigger a different control process on the back end. So a software hardware combination. It could also, there could be patents on the physical hardware or machine elements as well, like the keypad or how the battery works as a basic example, or how the memory is organized. That could be at the hardware level. You could also have, as I mentioned, memory at the software level too. So you could have an interplay as well as improvements. So similar to your IP strategy overall, you don't want your patents to just be set in this particular time point. You want to revisit those patents and making sure you're continuously filing new updated registrations to capture improvements, not just version 1 of your product, but also version 2, 3, 4, 5, and beyond. Similarly, as I mentioned, there could be copyright protection in the code, in the software code, as well as patents for the functional elements of the code. So there could be layered there, just as one example. You could also have copyright protection in the compilation of data. So if this device is collecting data, for example, and then that data is being strategically identified or selected, and there's skill and judgment used to generate a compilation of data, say an aggregation, for example, with some skill and judgment used, then that compilation of data can have copyright protecting it alone, those assets. There could also be copyright protecting the API, or the application programming interface. So if there is sort of a cloud service that's interacting with the device, there might be some API calls between the two, and that could be captured as a copyright in certain countries and jurisdictions. Also, in the user interface elements, you can see here on the screen, there's some graphics. Those could be original artwork, for example, of the company. And so there could be copyright in that. So this is just, a sample of some of the copyright that could be attached. But of course, not at the device level, but at the company level, there could be manuals or user guides for this device as well that could be protected through copyright. You would also have design protection. So that protects the physical aesthetic look of the article, not necessarily the functional level, which would be a patent, but that more physical aesthetic look would be a design. And so here you could have the hardware form factor, the shape of the device, for example, the layout of the keypad as another example. Also, that there's a user interface element that can also be protected as design, and it's being increasingly used. Designs are being increasingly used to protect user interface design features as well. You could also have trademarks in the mark itself. So this is an example with BlackBerry. So that's a company or a device level mark. And then there could be other, version levels. So there's the word bold on the back, for example. So you can have different layers of trademarks even within one product. You could also have a logo. So you can see the logo, and that logo might evolve over time. So another example of how not just to rely on your initial filing, but seeing how that logo or the product names evolve over time and continually updating your registrations on those names. Similarly, you could have trade secret and confidential information protect things that are secret on the device. There could be encrypted software within the device itself, and that software may be protected as confidential information. There could be backend server code interacting with this device, and that similarly could be protected by trade secrets and confidential information. Of course, at the company level, you could have market strategies or know-how or any other secret sauce to get your product working, whether that's on a manufacturing side or distribution side, for example. And so this just, is a snapshot with a simple example. I mean, very complex technology, but a simple example walking through the different types of IP rights at play. You can layer them all because, of course, you could have copyright protecting the code. It could also be trade secret, as well as patents at the functional level. And then the generated interface could be by a design, and that whole product could be sold through a marker or logo so you can see how they work together. Of course, as I also mentioned, contracts are generally relevant to IP assets as well. There could be licenses or terms of use. You could be using third-party components to build your overall product. So there could be incoming licenses. You could also be licensing your technology or your software, for example, through an outgoing license agreement. So important to pause and think of the contracts at play as well, not just the different intellectual property rights alone. I'm going to pause. I don't think there's any questions, but so I'll just keep on going. But if there is, please jump in the chat anytime. So as the original question, why do you need an IP strategy? So a second, area I want to explore a little bit today is creating a culture of IP and supporting the IP strategy and also the culture through your IP strategy. So you want to have engagement or encourage engagement by your core technical team, but also the business team. And that can be done through many different ways, but engagement and awareness are typically the focus, right? You want to excite your team, the people on your team to be excited about your IP strategy. I know not everybody gets as excited as I do about IP strategy, but it's important to try to create that culture internally so that people take it seriously and then in turn put time and energy and resources to the strategy. And it doesn't have to be, overwhelming to the team, just regular meetings, training, education as a starting point. You want awareness of IP and you want buy-in from the company leaders. If company leaders are saying this isn't of value to the company and that's their messaging, of course, that's going to be heard and that's going to probably reflect on a poor execution of your IP strategy or maybe even a poor development of that strategy. So, but if you have buy-in from your company leaders and they're excited about it, they're sharing the information, they're engaged, and that's going down to the rest of the team, then I see a lot of different examples where the importance of that to build a robust, strong IP strategy and portfolio of assets. So you want that awareness and buy-in from the team, and that will in turn create more engagement for the rest of the team. You want to build that solid IP foundation over time as a result of this education and engagement. So you don't want to just have a one-time training session and that's it. You want a regular recurring one. So we talked about evolving your strategy over time. You also want to have, ongoing training and education over time. So the company and the team, all the different members of the team are aware of that strategy and how it's evolving and how the portfolio is growing. You want awareness of the IP assets. So company leaders can actually speak about the IP assets. They understand what trademarks are at play, the key important ones. They understand the different patents in the portfolio. They understand the designs. They understand how everything works together. They understand the importance of confidential information, how it's a people management issue, and ensuring everything is indeed kept secret and there's protection measures in place and everybody's aware of what are those core confidential assets. So all of that stems from a strong culture of IP and awareness of those assets. You also want awareness of milestones, whether that is IP rights related milestones or product milestones. So before launching a product, making sure to check in with your IP strategy and team to say, hey, does this product fit into our existing strategy? Or do we have new developments that we need to file a patent on or patents on before we launch? Or are there other considerations around branding that we need to pivot for our trademark portfolio? So making sure that awareness of IP assets, but also product or company milestones and making sure that they're synergized together. As I mentioned, creating a culture of IP is really important from a people management perspective. IP assets, and at the starting point are in somebody's brain, right? Most IP is created by humans. I mean, we've got AI working away hard at this point, or not working away, but generating away IP. But whether that's actually protectable, is a loaded question. But generally, it's humans creating all of the IP assets. And also humans tend to disclose IP. And so making sure that everybody's aware of, oh, we can't disclose this, we got to file a patent for us, or never disclose this. This is our trade secret. This is our secret sauce. So making sure everybody on the team is understanding the importance of these disclosures or the impact of those disclosures and also product milestones. And then you want to motivate invention disclosure or IP disclosure more generally and celebrate registration, celebrate wins. We've seen some example companies that have galas or award ceremonies and really motivating people to bring forward the invention, go through with the time and effort needed and costs needed for patents, and then celebrate when you get one with the team, pausing and celebrating the wins. I think it's really important as part of the culture of IP. So those are just a few tips. Of course, there's a lot that goes into culture that we don't have time for, but here's hopefully some helpful things to take away. Two final points that I want to talk about from an IP strategy perspective is using IP strategy to identify opportunities, and whether that's through commercialization opportunities or strategic enforcement opportunities. So on the commercialization side, you want to be able to leverage your IP assets to support collaboration opportunities. So what you're bringing to the table should be clearly articulated, including the value of what you're bringing to the table, so that you can in turn swap or leverage those assets to obtain other value from third-party entities. Maybe your team is pro on the software side and you want to collaborate with another entity on the hardware side. So making sure you can articulate the value of those assets that you're bringing so that you can get favorable terms, or leveraging those. If you have an asset that is particularly valuable and a scarce asset, then making sure to identify that, and so that it's clearly owned by you in the agreement, but also leverage that so you can get access to other valuable, scarce assets that third parties have and work together in that agreement. So I find that that's an opportunity there to increase the value of your IP assets. If you find through all this effort protecting them, is making sure to leverage them to get to exchange or share in exchange for other assets that could be of value. You also want to pause and say, are we going to be developing new IP assets with either your existing assets or a third party's existing assets, or maybe just starting from a clean slate, but still making sure to pause and say, what are we actually going to develop through this collaboration? And that's another opportunity for new IP to be developed, but you also have to think about an IP strategy for that newly developed IP, particularly if it's jointly developed. There is generally a default to go to joint ownership, which actually can be quite tricky depending on the type of IP asset that you're looking at, but also the type of IP right that's protecting that asset. Joint ownership can be pretty complicated because it means different things. For example, in a basic sense, joint patent owners don't have to account to the other party. So you could go off and license to another person's competitor that if you jointly own it with that other entity. And so you want to make sure that you clearly understand the impact of joint ownership, but also thinking about how complementary IP assets work with the newly developed IP. Maybe you can never use the newly developed IP without access to that third party's underlying background IP. And so making sure to pause to see how everything works together and set that out in the agreement. Or maybe you have the asset that everybody needs in order to use the new asset, and making sure you're thinking about that protection and that opportunity for sharing as well, and leveraging that value. You also want to pause and make sure that the agreement terms align with your strategy, and that if one team is working on the agreement and the other team is working on the patents, for example, making sure those two teams are talking to each other. And so you're not filing all of these robust patents, but then putting ownership of those patents out the door through the agreement. So making sure that those alignments and conversations are happening, in particular if there's different teams. And as your entity grows and evolves, this is where there can be more distribution around those teams, and making sure everybody's checking in and there's alignment there. You can also, as I mentioned from the outset, the IP strategy is a defensive strategy to protect your freedom to operate. But of course, you also want to have a pulse in the market. And sometimes it makes sense to have strategic enforcement. Generally, enforcement, particularly patent enforcement as an example, but also trademark enforcement, can be very expensive. And so that's why we say strategic enforcement. So you're not spending all your money, all your time focusing on, starting enforcement against all your competitors. That could suck the life out of your IP budget and also your team's engagement. And back to the culture, if that's all you're doing is suing companies, that might not trickle down to a positive IP culture as well. So making sure to pause and thinking, sometimes it makes sense, and explaining the messaging around why it makes sense for certain times. It also can be frustrating if your team's constantly saying, look at all these competitors, they're just ripping us off. We've got to do something about this. So you also want to align that with your IP culture so everybody else isn't feeling frustrated, or you're hearing that team. And so making sure to not say no to enforcement, but just being strategic about it and selective. You can avoid or mitigate disputes as well. So you might You might see a player in the space copying you or using your technology, and you might turn that into a partnership agreement. You might reach out and say, hey, look, looks like you're really interested in our technology. You're using something that's our IP, but can we work together? We actually really like your, background system for this. Can we swap and do a licensing deal? So you can identify potential commercial opportunities through that enforcement lens, reaching out with sort of an invitation to license, whether it's just the IP alone or maybe your technology that matches. So you could license your patents, or you could license your technology and your patents together, as an example, your copyright and your software together generally, because they are so intertwined. You also want to ensure, when you're looking at strategic enforcement, is ongoing monitoring and awareness of the market. There could be new players popping up, big players pivoting into your space, new small entities forming and coming into the market. So continuously on looking at that market. So aligning back to the first point about making sure your IP strategy evolves, similarly making sure your awareness evolves. And that could be awareness in two different buckets. I just highlighted market landscape analysis. So who are your actual competitors selling products or services in your space? And you can also look at a patent landscape analysis. What companies are filing patents in your space? And they might not yet be offering products in that space, but it could give you good insight into people or entities pivoting into your space. So I break this sort of awareness into those two buckets: what's happening in the market, but also what's happening in the patent office, and seeing those together. You'll be surprised. Some entities pop up and you think, oh, I never even thought of that entity as being interested in my space, but good to know through their patent publication, and making sure that that awareness is ongoing as well. So I wanted to pause again for questions, but if there aren't any questions, I'm going to turn it over to Rachel and Angie from New Ventures BC, and they're going to talk about the exciting AccelerateIP program.
Maya, maybe before you jump off, there is one that we might be able to just sort of segue into before we hand it off, is one that was, are there special considerations for an IP strategy for data-focused business? Either data as the central IP or using it to help build stronger defensive position around the technology, for example, data sets, algorithms, innovation platforms, et cetera, just to kind of close us out on this.
Yeah, absolutely. So yes, data, there is IP strategy for data. I think given there is a little bit of uncertainty at how the strength of copyright protection in data, making sure you pause and say, how comfortable are we with the human and creation in involvement in this data? So is there human skill and judgment in any part of the data generation or data selection or aggregation, trying to bring a human in the loop as much as you can, and making sure that you're leveraging skill of humans to create those data sets, I think will help strengthen the protection of copyright. There's a Canadian case related to seismic data, for example. And even though sensors were involved in generating the seismic data, there were human skill and judgment involved in setting the parameters of those sensors. And so that was enough to give copyright protection as an example. So copyright is going to be a core asset for that data, particularly if the data isn't confidential. If it is confidential, making sure you control a disclosure of that data through non-disclosure agreements or confidential obligations, but also thinking about technical measures in place to protect that data as well. And making sure, again, if those technical measures are protecting that copyright asset, there could also be a layer of copyright protection, because you can't actually, under the Copyright Act, go around or circumvent those technology protection measures. That activity alone can trigger damages under the Copyright Act. So not just, even if they didn't use the data, but just tried to circumvent your protection measures, that works together. So making sure to think about that, not only to ensure confidential information rights come in, but also you can trigger those technology protection measures. And there could be patents as well, depending on how you're using data. Sometimes data isn't in the right form for training an algorithm. And so you might have training processes in place to improve that data. And that process alone could be a valuable IP asset. While it's not the data itself, it's valuable to and commercially valuable to unlock that data for those programs or those algorithms. So that's just a few comments on the data strategy, but of course you can dive into the nuances further, and making sure your contracts set up restrictions on use as well relating to that data. So you have contractual remedies available if needed. And I'm going to turn it over to Angie and Rachel, and they're from New Ventures BC, and they're going to talk about this exciting AccelerateIP program.
Thank you, Maya. A great overview. I'm always trying to find a good succinct way to understand the why of IP. So really appreciate listening to that. So hi, everyone. As mentioned, my name's Angie. I'm here with Rachel. We are both here as leading the AccelerateIP program, which is part of the AccelerateIP federally funded by ICED program across Canada. So we are leading BC, Yukon, Northwest Territories, and Nunavut, but we do have partners across the country that are delivering the AccelerateIP program nationally. So we're going to focus our talk here on our program, but if you are not in BC, just know that there is probably an equivalent for you elsewhere, and you can look that up, or feel free to ask, and we can tell you where to go. So I am going to pass this over to Rachel, who will take you through the program, which will be launching soon. And I look forward to hearing from you as after the info session's over. Rachel, over to you.
Thanks so much, Angie. And for sure, if I missed anything during my presentation, please jump in. Thanks so much, everyone, for joining, and thanks, Maya, for your awesome presentation. We're really excited to share about this program. So as Angie has mentioned, we're part of the AccelerateIP initiative, which is a Canada-wide program. But we are focused here, AccelerateIP, on BC, Yukon, Northwest Territories, and Nunavut. So as Angie mentioned, New Ventures BC is delivering this program. We also are working very closely with Innovate BC as a prime collaborator on this program, and they'll be delivering a lot of program aspects as well. Plus, we have additional partners and collaborators across our regions as well, who will be helping us with certain aspects of the program. And as Angie mentioned, if maybe you're not part of these regions listed here, you can also find other partners across Canada, recipients of this AccelerateIP program. So you can apply, say you're in Atlantic Canada, you can apply with Springboard. If you're in Quebec, you can apply with Maine. There's also Communitech in Ontario covering Manitoba, and there's Innovate Calgary as well. So lots of options depending on where you might be located. And just wanted to say that this program is supported by Innovation, Science, and Economic Development Canada, or ICED. So thank you so much for funding this program. And also just wanted to clarify, this program is also separate from the IP Assist program, which is delivered by IRAP. So we have a lot of partners and collaborators throughout our region. So they're all listed on the screen. I will not list these out loud, but if you might be a startup and you might already be associated with one of these organizations, maybe take note, as we will have a mentorship component to our program. And there will be folks from different organizations going through a program we're going to call Train the Trainer. And they will become mentors in the program that can help you sort of figure out how your IP strategy fits into your business plan as well. So that might be something that you can do with your local accelerator or incubator. As well, these folks may be putting on events or online events, in-person events throughout the region. So just something to keep in mind. We will have a centralized website to share all these events as well. And that'll be coming soon in the fall. And for now, any events that will be held for the program will be found on the New Ventures website, as well as on the websites of our partners, as makes sense. So AccelerateIP has 3 streams of programming. So we kind of want to meet every startup where they're at. So whether you're just kind of learning about IP for the first time, or you already have a really strong IP strategy in place, we want to make sure that there's something for everybody. While there are 3 streams, we don't expect that everyone might have to go through these linearly. It really depends on where you're at and where you're coming to us in the program. So we understand maybe it's certain circumstances, it might make sense that you can jump ahead. You might not need to do the stream 1 education, for example, but we do require that all folks, when they apply for kind of the later streams, they do demonstrate that they have an IP strategy in place. So to go over the 3 streams, the first one is awareness education. So it'll be events like we're doing here today, where we, take an opportunity to learn about IP. So again, those will be held throughout the regions. As well, New Ventures BC will be creating an educational series, and as well as our partners and collaborators will be also putting on events. Stream 2, strategy. There's 2 tiers here. So we have mentorship and also legal costs. I'll get more into these in detail in later slides as well. but just a quick overview is that you can get mentorship, one-to-one mentorship to go through your IP strategy, or you can get some legal costs covered. And then stream 3 will be all about implementation, and that's all focused on legal costs. So education, we will have free foundational content available, as well as seminars and webinars, and a really exciting certification program that is still awaiting a very fun name, but we will have a fun name for that at some point. But first of all, so free foundational content. We're in the works of developing some modules, but we will also have links that we can provide to really strong free foundational content that's already out there, for example, to CIPO, etc. We will also have seminars and webinars, as mentioned, and the certification program is a really exciting program where 15 startups can actually take a deep dive into IP. So you'll get to do a 5-day program with IP experts and really go into what your startup needs. So that's a really exciting program. It'll be happening in November, and look out for that one because that's a really unique opportunity. So some basic kind of eligibility and application info to share. So we are open to tech startups, as we mentioned before, in BC, Yukon, Northwest Territories, and Nunavut. We've created a really broad definition of startup just because we don't want to bar anyone from participation. So startup is under 500 employees, full-time employees. That said, we will definitely prioritize folks in the later streams for funding with startups that are smaller than that. But we just wanted to make sure that anyone could take part in at least education or other streams of the program. Tech is broad. We understand, there's all different kinds of ways to approach the definition of tech. What we really want to see is that you have an innovative technology that is the central to your business, or that you operate in the tech sector. So if you operate in the tech sector, that's pretty clear, but maybe if you're not sure if your technology counts, please reach out. We can help with that. So events are open to all, and just register on our register on New Ventures BC website for events or on partner websites. The foundational training, what we'll have is we're going to have a centralized application portal. So you'll be able to enter all of your information once, and then you can apply to different streams of the program. So we want to make it as easy as possible for you to apply and not have to kind of enter your information multiple times. So for foundational training, you just need to register, and we'll send you links as they come up. And as we develop more content, we'll be able to send that out to you. The certification program, as I mentioned, it only has 15 spots. We're aiming to offer it around 3 times a year. So there will be a competitive application process for that. And by competitive, we're simply looking for the best fit, and also that you have kind of some IP awareness before you might join that one. And no worries. So this program is running for 3 years, so until March 2026. So I just also want to say, if you learn about a stream and you're like, I'm not quite ready for that today, no worries. You could always work towards getting ready for that in later years. So please keep that in mind as well. And we look forward to seeing folks progress throughout the streams, throughout the program. This will open on our portal, hopefully August. We're working really hard to get it up very soon, or at latest September. So next up is strategy mentorship. So this is a really cool opportunity to get one-on-one mentorship. And as I mentioned before, it'll be with business advisors throughout our regions. And this is a great chance to look at how IP might also affect your business strategy. So, and just to clarify, these folks are our mentors, so they're not legal service providers, but they are experts at helping you develop your business. And so that's where they fit in here. So it'll help you assess your IP strategy, and you can get up to 8 hours per startup, one-to-one mentorship. This is also a great opportunity if you're like, I would love to work with a legal service provider on building a strategy, but I'm not sure where to start, and I really want someone to help me navigate that. Like, who do I reach out to? What kind of questions do I ask? What's a great quote amount? Like, how much should this be charging? How much should this take? How long should this take? This is a great opportunity for you to reach out to a mentor. Maybe you already have a mentor, or maybe you'll get a new mentor. So this is kind of like a bridging step in a way to get the support. This application will also happen on our portal. So you'll see a lot of things are repeated, so I won't go over the things that are repeated, but this will apply on the program portal. And for this one, you just have to answer some basic IP assessment questions. So they won't be too difficult here, like we're not expecting you're an expert, but just we want to kind of gauge your basic level of IP readiness. We do have some priority sectors. There's a bit of extra funding allotted to clean tech, health tech, data tech. And we also prioritize companies who have majority ownership by underrepresented groups. And this, again, will open kind of close in the fall, September, October 2023. So next, strategy, help cover costs. So in this stream of the program, you can get up to $25,000 for costs with the legal service provider, and this can help you develop your IP strategy. So New Ventures BC will cover up to $25,000. It doesn't mean everyone gets $25,000. You might only need 8, you might only need 10, so it'll be based on the quote that you provide to us from a legal service provider. This will help you develop your IP strategy, as I said, and there is actually a co-investment part to this. So startups will need to pay 25%, or if you have an Indigenous-owned startup, then it's a 10% co-investment. And here is a list of the eligible activities that we'll be allowing in this stream of the program. So if you want to take a quick look, I'm not going to read them all out to you, but you can look and see if what you're thinking of might be on this list. And of course, you know, this program is an early stage. When we launch, we're going to be doing it as a pilot. If you find that there's something that's not on this list, you can always apply for it, and we will take a look as a case-by-case basis. However, for now, these are the things that are approved to be eligible activities in this stream. So again, here's this information. You will apply on the program portal, and you must answer basic IP assessment questions, and the same priorities apply. For a little bit more detailed information on how to apply, we will ask that you get a quote from a legal service provider prior to us approving your application. So we just want to make sure that you have connected to someone, you found out what you need, and we can approve the amount that you have found. And that will be, yeah, that will be the basic. And you'll also have, of course, questions to answer as well. This will open in September and October 2023. And finally, implementation. So this is the bigger funding amount. So you get up to $60,000 for costs to work with a legal service provider. And examples of that might be actually filing your patent or registering a trademark, or etc. This has the same co-investment structure. And these are the eligible activities so far. Again, it's in a pilot stage. If we find there's something else we need to add, we will. But for now, this will be eligible activities. And just to confirm as well, it's up to 60,000. So it doesn't mean if you apply and you're approved that you will be getting the full 60,000. The main difference when you apply for eligibility is that you must be incorporated. So all startups applying to this level must be incorporated, but you don't have to be incorporated for the other streams. You'll apply on the program portal. And for this one as well, you must answer detailed IP assessment questions. So we really want to see here that you have like a really strong IP strategy already. If you apply and we're like, oh, you know what, your IP strategy is not quite there, what we'll do, we'll just suggest that maybe you go back to stream 2. So it doesn't mean you can't apply again, or again, this is a 3-year program. You could always apply in the future. But we want to make sure if you're kind of accessing this level of funding that you've got a solid strategy in place. This has also a competitive application process. So we will actually put your application through to a selection committee who will really analyze your application and make sure that your startup, you know, has commercialization opportunities, that you're kind of on the right track. And again, you have a strong IP strategy. It has the same priorities as well. And again, we're looking to open either September, October 2023. This comes up in phases. So just want to really thank you for listening today. If you have questions, feel free to reach out. We'll have a new email as well for the program soon. But for now, please reach out at contact@newventuresbc.com. We also have a spot on our website, just a placeholder page. You can kind of click that you're interested in learning more about the program. If you do that, then we'll add you to a list and we'll update you as soon as the program opens. So if you're like all ready to apply, feel free to add your name to the list there because we're happy to do that. And with that, I will stop sharing my screen.
Thanks so much, Rachel and Maya. And I think before we dive into the specific Q&A, kind of a set of questions for both from the New Venture side, DC side, as well as from Maya's presentation, is to be well prepared to work with a lawyer on IP strategy. You know, what's the best preparation that one could do, and sort of the follow-up to that for those folks, Rachel and Angie, who are interested in applying to AccelerateIP, you know, the level of legal consultation that may be required with counsel prior to applying, and are there considerations for folks to have those conversations in advance?
I'll jump in on the first one about how to prepare to engage counsel. I think, you know, just starting out, have a initial disclosure about how much IP sophistication you have. I think it just helps the lawyer match too. Sometimes they're not the best person to be the main consultant for you. And so having that just sort of initial disclosure is helpful. I find it helps me, tailor the meeting. I can jump in higher or lower or as needed. So just explaining your level of understanding and education, and also trying to, as best you can, articulate your IP assets as well. So you say, or your IP, so you don't have to talk about it from an IP asset perspective. You can just talk about what you think has value to your company. And so that way it helps prioritize too. There could, as I highlighted, there's so many different aspects of a robust IP strategy. And so prioritization is key, just from everybody's resources and time and energy. And so giving that sort of snapshot into what is valuable to the company is really helpful. You might assume your lawyer knows so much about your market or so much about your company. You probably, as the entity founder or owner, know the most. And so making sure that that's communicated to the lawyer really helps them highlight what should be prioritized and where the value should be focused. Angie or Rachel, do you have anything else to add? I know there was, the second question was somewhat similar, but should companies that are looking at your program, AccelerateIP, engage counsel before or service providers before, or just would you encourage them just to sign up and help, and you can kind of help guide them at that point?
Sure. I guess to be eligible for our program, you'll need to get a quote from a service provider before we can approve your application. So it's great to consult with one or a few service providers first and kind of see what that quote might look like. You don't need to engage further with that in terms of the program needs, but Angie, do you have anything to add there?
Yeah, so that's just for and if you're looking for the legal costs to be covered in stream 2 and 3, you don't need to engage with anyone for the awareness or the mentorship. We will also be building a legal service provider type of guide. So if you don't know who to talk to, aside from Maya, of course, who's here, then you can ask, and we can help give you some ideas, particularly if you're looking for a particular region or background or experience. So that's also being built.
Perfect. Thank you so much. Another question as well as we dive in is, Maya, you were sort of mentioning some excellent points around the data piece, which is also something of interest to those on the call. Is there sort of a good, simple resource that you may be able to point folks to learn a little bit more?
Yeah, I can. There's a few resources, so I can share that with you, Jen, and then you can.
Perfect. We can share that with the audience.
Yeah, okay. Absolutely. And one other point I wanted to mention around data is making sure you're pausing and understanding the sources of that data as well. If you're creating the data yourself as the company, you have a lot of control over that source. You're the creator. So if it was protected by copyright, you'd be the first owner. But I think there's a common misconception that just because data is available on the internet, it's free to use without condition, which is not necessarily the case and often not the case. So terms of use become very important if you're pulling it from a platform, making sure if you're not compliant with those terms of use, you might be on the hook for copyright infringement. So you might be pulling a bunch of data into your data pool, and you don't have permission from the data owner to do what you want with it, and that can taint the overall value of your IP and that IP rights in that data. And we're sort of seeing that play out already with generative AI as an example. All of these data sets, nobody understood how these systems were trained or what data is into those training data sets. And if they were obtained in an unauthorized manner and not compliant with the terms of use attached to those data sets, then that could be copyright infringement or other type. If it was confidential and you're sort of circumventing confidential protection measures, for example, that could then be trade secret or confidential information issues as well, depending on the country that you're operating in. So making sure to pause and say, where did we get this data from, or where did my team get this data from, is a really key issue. And a lot of times, even when data sets are offered free on the internet under an open source license, there still are terms of use, but often they're offered as is. That data set's offered as is. So you have even if you're compliant with that high level data license, you don't understand how that third party generated that data set. So, and you're using at your own risk, and there's no reps and warranties attached to that data. So you might be on the hook as sort of that third or fourth user of the data, even though you didn't create the compilation or the aggregation initially.
Wonderful. And sort of a question around sort of the legal side of things is twofold. One is, when selecting a lawyer, is it best to find an IP specific lawyer or to use a business lawyer? And for Rachel and Angie, specifically for those who are sort of seeking counsel, are there sort of caveats around, you know, what the lawyer that one should be seeking as they want to apply?
I'll just jump in saying I always think it's helpful to get an expert, an IP expert. So I wouldn't necessarily rely on a general business lawyer, but there's a lot of lawyers that have focused in on technology as sort of their practice area, and they might straddle business as well as some IP, or they might be a commercial contracts expert and really good at IP as well. I see that a lot. And so just pausing and making sure you ask if they have the expertise. I think business law or IP, they can be connected as well.
And
Yeah,
just,
I would agree with that. Sorry, go ahead, Rachel.
No, go ahead. I was just saying, kind of like what Angie had said before, we will be building a service provider database. So these folks will be vetted by us. And so that's kind of a first starting point. But you can also bring your own legal service provider to the program. So if you have someone that might not be on our list, that's totally fine as well. And we'll just have kind of a quick check, and can add them then to our list. So that's kind of the way that our program will work. And Angie, sorry, did you have something else?
Another question that, oh, go ahead, Angie, sorry.
I was just gonna say, I agreed with what Maya and Rachel said, which is, you know, I probably wouldn't go to an IP lawyer for business law guidance, so probably shouldn't do the reverse either.
Perfect. One that's come in is sort of around the overall budget for the 3 years, and just clarifying sort of the timing of the streams that they're all opening, roughly around that September, October window.
Sure. Rachel, I'll let Rachel talk about timeline, because that's everything she's managing. The overall budget for Elevate IP federally is, I believe, around $90 million committed. So that's divided across the country. For the regions of BC and the 3 territories, there's around $12 million total for the next 3 years.
And in terms of timeline, we're looking to open everything kind of at the same time, with education opening a little bit earlier because the application process is a lot less complex. So we're aiming to open September, October, but what we're going to do is open it as a pilot at first. So we'll have a shorter application window, just kind of see what kind of applications we get, how things are going, and see if there's anything we need to modify before opening further. So we will notify you on sort of the window on our website. We'll have all clear kind of guidelines as to timeframes, and we will be posting that shortly. So we'll have kind of, you can more prepare. And if you don't make our first window, then we'll open another window later. So no worries if you kind of missed that first September, October deadline. It's no problem. We'll open another one shortly after.
Okay, and specifically around sort of the implementation stream, but may also sort of factor into the other program streams, are there any restrictions on what can be done with the IP that is obtained through the funding?
That's a good question. Angie, any thoughts on that? I don't.
I mean, we'd have to know the actual situation, so I don't want to give a blanket answer, but I would say the point of this program is to improve the kind of IP development and capacity of intellectual property development in Canada. So we're looking to improve that state. So you know, keep that in mind. That's kind of the spirit of the program.
Mm-hmm. And it could be too that the question may be getting at, like, is there now going to be stars beside patents that were obtained through funding, and that you now have to, you know, offer them up on certain different terms, or they'll be not somehow encumbered or something. I think maybe that might be an issue potentially, but I don't think that's the case. But maybe that's where Julian's going with this question.
Perfect. And if folks have specific questions, and they can reach out directly and ask that more. Okay.
Mm-hmm.
When it comes to startups and fundings, there's a huge chicken or egg situation. We can't get funding without IP, and we can't get IP without the funding. So is there sort of something more that we could sort of speak to around, you know, those that may not have access to lawyers sort of, you know, or legal fees and, you know, if they don't have much of a budget, prioritizing what they should pursue, et cetera?
Mhm. Well, I think that's where this program is fantastic. It's meant to try to eliminate that or reduce that issue the best they can. So depending on if you're early stage, there's that early stage stream or the different streams depending on where you need to go. And so that's, I think the intent is to get to this issue. You might not have funding, but you need an IP strategy. Will come here as a starting point. And if you, even if you haven't spoken to a lawyer or other service providers, they'll help you, point you in the right direction and try to build up that knowledge without making you incur all those costs. And then they will support those costs to a certain degree, and of course within the parameters of the program, but to help you build that awareness, education, but ultimately those registrations that are probably the expensive bucket that you're pointing to as well. So I think this is the place to go. Talk to Angie and Rachel.
Yeah, I'd say that's kind of what the spirit of our education awareness stream and the mentorship side of our strategy stream are. Hopefully give you the ability also to understand how to prioritize relative to your business. I will also mention that there is also, if you're an IRAP client, they do run the IP Assist program, which also has an awareness stream with, I think, a lot of similar services as well. So definitely look at all the options you have available to you.
Mm-hmm. I just want to jump in because I see a lot of these sort of funding questions. And I think an area to pause and prioritize is at this early stage is patents. I think patents are very important, but you don't necessarily need 20 patents. And you don't need to patent every aspect of your product either. But focusing on a bunch of or try to identify the core components, things that, you know, maybe work across the product line, or that you really think, you know, if this wasn't protected, this is core to our system, it wouldn't work otherwise. Focus on 1 or 2 filings on that core asset. I think it speaks to investors and your other interest holders that, look, we are serious. We're okay to put some of our funding into the game. We need to clearly define it. If you only rely on contracts, that can be a problem because your remedies are pretty much limited to those contractual remedies vis-a-vis the other party, whereas a patent is sort of you and the world. It helps protect your freedom to operate because it then rejects later filed applications for similar subject matter. So just focusing on 1 or 2 patents could be a good strategy early on, and then evolve as you build funding and see the value and see that process. But and there's also unregistered assets, as I mentioned, copyright, as well as there could be trademark rights. I don't necessarily recommend relying on common law trademark rights. It's tricky from an enforcement and just determining whether you have the right to use. But copyright is automatically created. So some core assets for companies could just be in the software code or other parts of their business. So thinking about assets that you don't have to incur a lot of registration fees, like copyright, could be a good one. And then confidential information and trade secrets. Of course, there's not a registration process for that in Canada. But at least if you can have good management skills and making sure everybody keeps that information secret, you have that asset there without incurring government fees and from the patent and design perspective. So there's something can be done with not a lot of funding. And you could also say, look, we don't have the money to file these 10 patents to your interest holders, but we would love to. And then you can start building that as part of your fundraising strategy. And so you have a line item for that. So there is a way to do something. And I see a lot of companies using limited resources very effectively, particularly if they have engagement of the business leaders, because they're, you know, making sure that they're efficiently using their service providers and not putting a lot of the education onto that, or making sure that they're coming to the table with robust disclosures and what have you. So I think a lot can be done, and making sure, again, to check in with the program. And that's the intent there, to help make sure that a lot can be done without incurring a lot of costs, can be done efficiently, and they'll help you, support you on that.
Perfect. Thank you, Maya. I think also one question that comes in, I think specifically, is around sort of how the provincial IP strategy funding fits into program delivery, but I'd like to expand on that a bit and put it out to you how sort of there's that tie-in with the provincial IP strategy and the work that is being done sort of provincially and nationally, if you can all speak to that.
Sure. So for the BC provincial IP strategy that was recently announced, that is a IP strategy that the province of BC developed and is based on their own priorities. That said, we have certainly spoken with a lot of the people at the province as they've developed that strategy. We do have some areas where we're going to partner, and they'll be able to help. An example being the certification program Rachel mentioned. They really want to be able to add even more seats to that so we can train even more people. I believe the province is also creating an IP hub to help navigate a lot of the landscape here, but it is a separate priority. So there are a few different kind of IP related initiatives all happening, and rest assured we all speak, and the intent is to make sure everything is complementary, but there is a little bit of, there is a bit of separateness to them as well. So we're all collaborating, but they are all slightly different.
Wonderful, thank you. And just before we hand off for the end, some of the questions that are very sort of specific around, applications, et cetera, we'll answer some of that in the post-webinar email and can kind of direct you to the resources through Rachel and Angie. But I just wanted to say sort of in closing is, what's one key takeaway that all of you would like to leave the attendees with before we hand it back to Zane to close us out?
I think developing, education and awareness and engagement is key as a starting point. And there's lots of great resources out there, including this program, and use these programs, and it doesn't seem so overwhelming or so cost intensive. Thank you, Jen, and thank you, Angie and Rachel as well.
Yeah, thank you. And thank you, the Supercluster, for hosting us. My takeaway is super practical. newventuresbc.com. That's where you can find more information on the program. And it will be launching over the next, I'd say, 4 to 6 weeks. So please keep your eyes peeled, and more info is coming.
And my key takeaway is just there's something in the program for everyone. So don't feel like if you don't know anything about IP that you can't take part in the program, and that, no matter where you are in your journey about IP, there's something in the program for you. And if you have any questions, please reach out, because we're super friendly and we're happy to answer any of your questions. So don't be afraid. There's no dumb questions. So please feel free to reach out.
So amazing. Thank you so much for carving out this time. And it's an exciting initiative for our province and an exciting time for our country as we embark in this. And so with that, I will hand it back to Zane.
Thank you, Jen. Thank you, everyone, once again for joining the webinar today, hosted by Digital and our wonderful IP manager, Jen. The recording of this webinar will be available on our YouTube channel and website, and all those attending today will receive a follow-up email that Jen has spoken about in the next couple of days with any of the resources discussed throughout the session. And that is it from Digital, and we'll see you at our next IP session. Thank you. Goodbye.
Thanks. Have a good one.
Thank you.